Good afternoon, everybody. I would like to thank everybody that has joined us for this glorious day. As always, I've got a little bit of housekeeping to start with before we get into the actual webinar. My name is David Furman. I'm one of the attorneys here at Altitude Community Law, and I am so excited that you have joined me on this wonderful July 23rd, 2025 to go over the annual case law review extravaganza. On your screen, you should primarily be seeing the PowerPoint presentation, the big thing in the middle, with the presenter, me, on the side. On the right side of the menu, you'll see a private chat icon. Please use this icon to type in your questions throughout the presentation. For anybody that has ever attended one of my wonderful webinars, I like to be interrupted. I like to answer questions contemporaneously. It is so much more fun to interact and engage with everybody that let's just have some fun today. Questions will be addressed. Well, my little paper says at the end of the webinar, but as you know, it is not the end of the webinar. I am going to talk to everybody now. If you have any audio or video issues during the presentation, please click the no audio or video button below the PowerPoint on your screen and follow the instructions. And I would also recommend maybe turning it on, turning it off, kind of the IT fix for everything. But please follow the instructions. Don't do that. Okay. One CMCA credit certificate will automatically be generated and emailed to you within 48 hours after the webinar, assuming you attend the whole program. You cannot leave early. You can't leave before I leave. You got to stay for the whole time. These credits are, of course, non-transferable. They are personal to you. Please save the image of the certificate that is in the body of the email if you wish to preserve the image. To save the certificate, right-click on the image in the email and save it as a photo. The image of the certificate in the email will only be available for 30 days, or you could go old school and print it. As a reminder, this presentation will be recorded to add to the Altitude YouTube channel. And I hope you all like our YouTube channel because you can go out and look at this wonderful presentation whenever you want. It'll, of course, take a couple days to get there. Lastly, well, not really lastly, but there'll be a survey that will pop up at the end of the webinar. We truly appreciate your feedback. You can provide your thoughts and opinions, assist us with improving future presentations, so please don't hold back, particularly if you do or don't want me to ever teach again. Alina takes these very seriously, and if she says that, who knows if I ever get to see you again. All right, with all that being said, let's get on with this wonderful presentation. This is something that has kind of been skipped over the last few years. And it's been skipped because the Colorado courts have kind of been, the cases coming out of the courts have not been sexy. They have not been, ooh, wow, this is really going to be wonderful to us. And therefore, we haven't really done it in the last few years. But I think I'd like to catch up. So some of these cases are not necessarily 24, 25 cases. They may go back a little bit in history. And not really, they're more historical in nature, and we may have already known them, but I didn't want to talk about them. So with that being said, the first case is a wonderful case, and I'm going to preface this before I show it to you. I need you to all remember some of the meetings you've attended. And when you attend your meetings, you've got the one individual owner that is somewhat cantankerous, somewhat angry, yelling and screaming at the board, yelling and screaming at the management company, and calls up and says, you know what, I'm just going to run for the board. And unfortunately, that particular member is not current in payment of assessments. And many associations give us the question is, well, the owner's not current in payment of assessments, can they run for the board? And I'm pretty sure every one of you has heard our standard stock answer, well, what do your bylaws say? Do your bylaws say that they can or cannot run for the board? Well, that is the exact situation in our first case, Majerski v. LCM Property Management. And I want to make sure that we all understand that this is an unpublished case. So it absolutely does not have any real precedential value other than you kind of get a glimpse into how the Court of Appeals may or may not think about this particular topic. So Mr. Majerski, an owner in the community, who was delinquent in payment of assessments, reached out to the management company and said, hey, management company, can we I want to run for the board. And the management company, without thinking about it, just turned around, fired off an email and said, you're delinquent in payment assessments, you're not qualified to serve on the board. Well, of course, Mr. Majerski, being the cantankerous owner that he is, sued. But he didn't sue the association. He sued the manager. And in suing, he was one pro se, and he argued the action violated his First and 14th Amendment rights. And this is the problem with how he pled his particular case is, again, it's, due process and First Amendment rights of speech and the like. And the court came back and they did look at the governing documents, and they concentrated in saying the documents do specifically state your right to vote can be suspended. And then it made the leap to, it can then be reasonably inferred if you can't run, if you can't vote, you can't run because you don't have proper standing. And I will tell you, generally speaking, I don't necessarily agree with how the court handled this, because I think had Mr. Majerski been represented by an attorney, this case probably would have come out a little differently, other than, like I said, concentrating on First and 14th Amendment rights. If he'd concentrated on more of the governing documents, that there was no prohibition from running for the board, there was no board member qualification for serving on the board of directors. And without those qualifications, he should be allowed to run and serve, because a homeowner vote is not a board member vote. These are totally different votes in the community. So I'm somewhat hesitant to, scream or jump up and down and say, we have this super cool case that definitively answers the question of whether or not a board member who's delinquent, or a member who's delinquent in payment of assessments, can run and be elected to the board. Because if you take this out again, the logical conclusion is that if a board member becomes delinquent in payment assessments, they're, by nature, they can't vote, and therefore that board member's vote is suspended, if you will, and you have quorum problems, you have the inability to handle other business of the association. So I don't necessarily advise we rely on this, but I do want to kind of give you that information and keep it in the back of your pocket, is to, you may have the ability to, again, at least we have an appellate court decision that says they can't run. And Nicole, that's my point. This is confusing because you have a situation that you don't have real clear guidance. We do have a case. It's unpublished. You can't really wave it around saying a delinquent member can't run for the board unless it's specifically in your bylaws. But we do have at least an insight that if it does come up, how the court may rule on it. So my advice on this, as not being many of your association's attorneys, or I hope I am your association's attorneys, is keep this in your back pocket. If you do have an owner that is serious delinquent and running for the board, we can have a discussion on whether or not they can run, or whether or not, and there is, it's let me see the whole thing. Concentrating on the governing documents, while the right to vote may be suspended, it can be reasonably inferred that if you can vote, if you can't vote, you can't run. Thank you for the typo correction. If you can't vote, you can't run. And it's that damn autocorrect on my PowerPoints. So, yes, Joan, there is a typo. Thank you for catching it. And Jack, in answer to your question, it's glorious because the sun is shining. And my cowboy hat's at home because it's 100 degrees out, and it's a rabbit for a cowboy hat. That's what the cowboy hat is. All right. Next case, premises liability. And I with some, again, hesitation with this particular one, this is a highly fact-specific case. And it involves the Premises Liability Act. And this is Willis v. Twin Shores Master Association. And with the problem with this one is, again, it's cert for the Supreme Court has been asked. And so you've got the association, which was not the prevailing party in this lawsuit, Well, actually, it was just the one question in this lawsuit. It involves the duty owed to an invitee into the community versus a duty owed to a what is referred to as a guest and or an owner. And what happened was Miss Willis, who is may or may not be the girlfriend, wife of an owner in this community, whether she's an invitee into the community in relation to the Colorado Premises Liability Act. And the Colorado Premises Liability Act has a differing duty of care as to an invitee or to a trespasser, if you will. And it really comes down to, this case is so full of issues that, again, it's one that I hesitated to bring up, but it's out there, so I wanted you to know about it. Is somebody, if somebody is living with somebody in the community and is a wife of an owner in the community, they're going to be an owner, they're going to be a guest in the community, and you're going to have a higher level of care, or an invitee in the community, you're going to have a higher level of care, according to the Premises Liability Act. Now, the problem with this case is the Premises Liability Act states one thing, and it's very clear what it says, and it occupies the field. What's referred to as occupied the field. So it's you either hit this line, you either hit the standard, or you don't hit the standard. And the court, the appellate court in the Willis case, extended the definition out, and it kind of redefined it. So that's why it's being appealed to the Supreme Court. Of course, the other problem with this case is not only what the standard of care was, but we're not even really clear. It was not, since it didn't go to trial and all the evidence was presented, we don't even know where Miss Willis slipped or fell. And it may not have been on association property at all. So that was one of the issues that is going to go, when it gets remanded back down to the trial court, that we're going to have to find out where exactly she fell. But I did want you to know, is one of those things is, when you have a slip and fall in the community, you need to determine exactly who slipped and fell and why were they there. And if they were there for one reason, are they a guest, owner, invitee, or were they maybe a trespasser in the community that you absolutely do not have a standard of care for that particular person? So with that being said, I'm going to slow down in my speaking a little bit because I'm going through faster, but we'll go to zoning changes. And this is a tale of woe. This is a tale of that I am almost going to be coming to theaters near you soon. And Donna, I know you're lost on the guest or invitee and how it works. It all gets to a standard of care of whether you have to warn people of, here, and let's kind of go back for a second, whether you have to warn people of certain conditions, or whether these conditions can exist and you don't have to provide a warning because they shouldn't have been there anyway. And a guest and invitee have kind of the same definition, but it gets to, why are the people there? And if they were not invited into the community, you do not necessarily have a duty to protect them from the dangers in the community. So, and like I said, this particular case, Ms. Willis tried to claim, well, I live in the community. I'm this person's spouse, girlfriend, and I'm regularly here, and therefore you owed me a higher standard of care to warn me of this danger, versus I was just walking through the community and I have no ties to the community. I was essentially a trespasser and I slipped and fell. Then you have no duty to warn them and no duty to indemnify them for those damages. And that's, again, it's highly, highly technical on that status, or the status of what you are in the community and that standard of care, which, again, when that comes down from the Supreme Court, we'll probably be talking about this again next year. All right, zoning changes coming to areas near you. Given all of the legislation surrounding housing, and given all the legislation surrounding the state's goal of providing more and more housing in different communities and redevelopment opportunities. And you've seen, the legislation for auxiliary dwelling units. You've seen legislation come in for transit-oriented developments, and that's a very specific definition of what a transit-oriented development is. And you've seen, headlines on the King Soopers on Colorado Boulevard is being torn down in favor of housing, and there's a community right next door to it. You see headlines on, that this building is being torn down to provide more housing in the community. And so you have a situation where these zoning changes going from commercial to residential, going from low density to high density, going from open space to housing to begin with, these zoning changes are going to come more and more frequently. So the case behind this is you've got a town in Telluride, which has a PUD, which is a planned unit development. It's its own little zoning classification. And Jack, I'll come right back to your question in just a second. Created 37-acre lot in this PUD, and it defines it as open space. So lot A is open space, it's 37 acres. It is right next to, let's call it what it is, a community in Telluride of multi-million-dollar homes. We're talking $5-6 million homes. And of course, the neighbors, they were not pleased. When Lot A's owners sought to have it rezoned to permit affordable housing, and they wanted to put 90 plus some homes on this tract, and the town, bowing to pressure from the community, denied the rezoning request. And of course, the owner of Outlot A, which stands to make a lot of money, sued. And essentially what the Court of Appeals, the Court of Appeals reversed and says existing case law clearly establishes that zoning and rezoning are legislative in nature. Regardless of the size of the property involved, the PUD was legislative in nature as it construed a rezoning of the property it applied to. And amendments to legislative acts are also legislative in nature. Arguments regarding the effect of a proposed rezoning on the rights of other lot owners were not ripe, so essentially the court could not hear them. And I've got my statements. Let's call it was 13 multi-million-dollar homes tried to prevent affordable housing community of 95 homes next door. That's really what happened. Now, again, it's the court, the appellate court, really ruled on the fact that zoning is legislative. It's not or it's legislative, it's an administrative, and unless the plaintiffs can show that the town abused its discretion, and in this case they did, they're going to allow the housing, they're going to allow the zoning change. This is not something that is right for owners next door to prohibit if the town wants to get something accomplished, or if an owner wants to get something accomplished, which again, this is really going to start coming up in a lot of areas as these, kind of old commercial properties get rezoned for housing. And the housing is the primary goal of the state, particularly in, resort communities where housing is scarce. And so, the Tellurides, not the Dorenas, the Purgatories, the Aspens, the Vales, where you have failing commercial areas, and the owners of the commercial areas may want them turned into housing and high density housing, high density affordable housing. These decisions are going to, like I said, start to permeate their way down and really become problematic. And it says For those of us with metro districts, if the metro district owns the property but the association maintains the property, can the premises liability should be shifted to a governmental entity and covered by the Governmental Immunity Act? And the answer to that is yes, it can. And that is a brilliant statement. And I, hang on just a second, let me see if it's in here. If it's coming up. No, it's not. I did not include the case that came out of the Colorado Court of Appeals, and it was Burlingame v. APSHA, the Aspen-Pitkin County Housing Authority. And this is to Jack, this is to your point. What happened in Burlingame v. APSHA is APSHA built an affordable housing project, and it was so replete with defects that the association sued, and it sued the declarant, the Aspen-Pitkin County Housing Authority. And the Colorado Court of Appeals essentially said that, well, we understand, the owner's plight, and we understand the owner's problems. The fact is, this falls square within the Governmental Immunity Act. And falling straight into the Governmental Immunity Act, Burlingame has no cause of action. So essentially, the appellate court's decision effectively stated, if you bought affordable housing from a governmental agency, and you're going to have absolutely no recourse for any defects that may have been built into those, because the Governmental Immunity Act. And Jack, to that very question, can you shift the liability to those owners, the district, that the property owner? Yeah, you sure can, because they're immune from liability for anything that was not grossly or not negligent. And in this particular case, these are not negligent-based losses. So I think it's, if you have a metro district, that's where you're in pretty good shape. All right. And then Donna, thank you so much. Town of Erie having begun to do this, not sending out proper communication of those changes. I think the proper communication is a problem. They should absolutely be communicating with the neighbors, but again, they're going to make these changes kind of in spite of your neighbors, or in spite of the objections. A lot of the legislation that came out of the state of Colorado really meant to eliminate what I refer to as the NIMBYism, and it states it in the legislation that they find that neighbor objections are a primary cause of rejecting affordable housing or rejecting the construction of housing. And they have rejected that, and they have legislatively removed a lot of those objections from it, which is, again, why you end up with zoning changes and decisions like this Telluride decision. And then, Nicole, owners aren't concerned about property values because, again, who wants to look at, a particular situation where, again, you tear down what is a single, maybe a two-level King Soopers or a two-level grocery store that is now being torn down, and they want to build a 5-story apartment house or a 5-story condominium community. These are going to impact property values. They're going to impact views. They're going to impact, traffic. They're going to impact all sorts of other things. Where if you kind of go back to last year's ADU legislation that says, an association cannot prohibit the construction of auxiliary dwelling units in an auxiliary dwelling unit subject supportive jurisdiction, and then goes on to state that when these are planned, you cannot even consider parking considerations. Again, it's meant to eliminate objections to, well, there's not enough parking if you build a second house. Well, the state's not concerned about that because, quite frankly, the state wants you out of their cars anyway. Going on with that, yeah, it's all about property values. Bottom line, it's all about property values. So, rights of first refusal. This is a case that I was actually kind of personally involved with, and I will tell you, the real loser to this was Mr. Gabbard and all, or Mr. Glickman. I'm sorry, not Mr. Glickman. The facts of this case is Mr. Glickman, who was the owner of the property, wanted nothing more than to do to sell his unit in the association and go off into its sunset. This is a community in Aspen, and in Aspen, many of the old documents, old condominium association documents, contained rights of first refusal. And those rights of first refusal were essentially that states if anybody in the community receives a bona fide offer to sell, they must send out notice to the owners in the community, and the owners in the community have a certain amount of time upon which to essentially have that offer, have that contract assigned to them, because they have to perform on the exact same terms and conditions of the offer that's received or the contract that's signed once they get that. And if nobody responds within a certain amount of time, it's deemed waived, and then the association issues a statement of compliance to the title company, and the title company can close the deal. And so Mr. Glickman received an offer to buy a unit from his neighbor and the unit owner within the community, which triggered the mandatory right of first refusal. Another owner wanting to purchase the same unit submitted an acceptance. And then, of course, this case ensued. And the question is does an owner, does the sale of a unit to another owner trigger the right to require other owners in the community to be allowed to essentially accept the offer to sell this, to buy this unit? Because remember, the entire purpose, we'll go back and do our history lesson for about 2.5 seconds. And one of the reasons rights of first refusal were originally put into corporate documents or to declarations was discriminatory in nature. It was to redline out certain undesirable buyers into a condominium community and to give the owners some level of, we can make sure we know and like who is coming into the community. And with that being said, so they wrote these documents in such a way as, again, to say, upon receipt of any offer to purchase, it triggers this right of first refusal. But what happens when the offer comes from somebody inside the community anyway? That they're already bought in. They have a right to buy the unit. So does that mean it comes across as, if I give you, I own my unit, you own your unit, you want to sell your unit to me, do I have to essentially give you an offer and then say I exercise my right of first refusal at the exact same time to cut out anybody else that can buy the unit? And the holding in this case was Glickman's offer to Gabrick was not an offer from a prospective purchaser, lessee, or tenant. It was instead an offer from an owner. Thus, the right of first refusal provision was not triggered. And it was, again, very language specific, because it states if somebody received a prospective purchaser, lessee, or tenant, that triggered the right of first refusal. But because it was instead from an owner, the right of first refusal was not triggered. It's, again, and the real loser here was Mr. Glickman, who was prevented from selling his unit for a period of, 18, 19 months, 20 months while this worked its way through the courts. And in a footnote, though, the court recognized that the right of first refusal provision was almost identical to a right of first refusal in another case, or Nichols' Cyclopedia of Legal Forms annotated, except for the forms from language triggering the right of first refusal, when the owner receives a bona fide offer from a prospective purchaser or tenant, including an offer from another owner. So the court ruled that because this other document, the kind of the baseline document, this encyclopedia of rights of first refusal, included owner and this one didn't include owner, that's why it ruled this way. I don't necessarily know if that's true. It is true that drafting is critical when you draft up these rights of first refusal, but I think the court was just kind of looking for a way to get this resolved without the headache of how do we resolve a complaint with two owners, which is why my general advice is if you have a right of first refusal, get rid of it. Just don't. I'm not a fan of these. 3 rights of first refusal in a row with associations I represented all ended up in litigation over how to do this. There's just not enough meats on the bones of these. Who actually gets to do it? Because in a lot of these, the encyclopedia or the drafting of this usually says it's the association that can buy the unit, not an individual owner. So the real requirement is you really do need to make sure that you look at these, and if you have them, quite frankly, I highly recommend trying to get rid of them. I know some associations like them, and usually the first thing I do is, because these are in older documents, it says it's triggered to the life. It's triggered by the rule against perpetuities, and essentially this is an arcane common law statute that says any interest in land must vest within 21 years of the death of a life and being. So this is an interest in land, your ability to buy a unit, and kind of you're getting, real property law 101. So if it vests at all, it's got to be done within 21 years of a life and being, the death of a named person. So usually what they do is they name the declarants in the community. And if it's the declarants in the community, then you got to do a search to see if they're still alive. And it's amazing how many communities actually know whether or not the people in these rights of first refusal are still alive, because they actually pay attention to them and they have to look for them. That's the first thing I do. When somebody calls and says, hey, we've got this right of first refusal, is it triggered? I go and look and see if it's still even valid, because many of these documents are from the 60s. So I'm going to take 2 seconds to go through some of the comments. Why is there no governance about companies buying multiple homes in HOAs, or is it there? There is, Nicole, there is no guidance or governance regarding companies buying multiple homes in HOAs. There is FHA underwriting guidelines that says if a single company and or entity owns more than 10% of the community, they're not eligible for FHA loans, which is problematic. But if your community wants to prohibit that, again, first and foremost, it's got to be in the declaration. 2, if it's in the declaration, it's got to be well drafted, kind of like these right of first refusals. You need to make sure that you can get at kind of all the potential common ownerships, because if I come in and I buy one under DAF LLC, and I own it one, and the next one I own is DAF2 LLC, DAF3 LLC, then I own 3 units in the same community. It's all really me, but it's 3 separate ownerships. So you need to make sure you draft to get at that. Plus, then how do you get to kind of all those deep layers of, are you going to make sure that, if it's, like I said, usually they go in with the address 501 Main Street LLC, and then they buy the next one in 508 Main Street LLC. You need to make sure that you get a common ownership group, and it's a common ownership group, meaning a majority of their interests are in the same control of the associations in the same entity, or majority of the interests are in the same entity, and we just need to make sure that we're able to get at that. What about the context of affordable housing project where the city holds the first right? You can't get rid of those because the city holds the first right. That's part of their loan documents. But those are usually pretty straightforward in that it's part of their deed restriction. And I have less of a problem with that because it's going to one person or one entity. It's not going to a free-for-all with the owners. But that's a good question. Fred, where would you find the ROFA? The ROFA, it's in the declaration. It has to be in the declaration. It's usually towards the end in the miscellaneous provisions, and like I said, it'll start with any owner receiving a bona fide offer to purchase or lease a unit, and then it'll go into how long the lease has to be. Usually, it's for more than a year. It has to give the right of first refusal to the other owners in the community. Yes, this is, Nicole, in answer to your question, you of course need an attorney for this because this is fine drafting, and hey, we get paid by the word, right? So, we need to make sure we go through that. All right, here is another case, and this is a very important case. Again, this is one of those that came out in 2023. It wasn't highly publicized, wasn't highly advertised, but it is definitely an area that you're going to stub your toe. And quite frankly, it has changed how we as attorneys respond to records requests. And the facts in this case is Heather Gardens, which we all know and love, is a large age-restricted community. During the COVID pandemic, Heather Gardens availed itself to a PPP loan, which loan was ultimately forgiven. Mr. Seaman, desiring to see where the money went, requested the bank statements, which were denied by the association. This suit resulted, and essentially what the association responded is, quite frankly, what we would have responded is the requirement is in 317, as you all know, is that the association provide detailed records and receipts of expenditures and the finances of the communities. What the association did is it gave its P&L statement. That's a detailed record. It shows all the inflows, it shows all the exflows, it shows where it went to. It also, the association provided copies of the balance sheets reflecting the funds as an asset, but failed to produce the individual bank statements, claiming they were not within the scope of Colorado's sole records of the association specified by statute. And as you all know, as I hope you all know, is the first line of section 317.1a or 317.1 states, for purposes of inspection and copying, in addition to those records received or required pursuant to the bylaws or declaration, these are the sole records of the association. And Heather Gardens, being an older community, did not necessarily have a list of more specific records. So we thought, the association thought, well, we gave you balance sheets, we gave you the P&L, we gave you fund balances, we told you how much money is there, how much money is in the community or in the association's account. And of course, Mr. Seaman wasn't happy. He said, no, you have to give me bank records. You have to give me, I want monthly bank statements. Those are detailed records. Your P&L isn't. I want where the money went, who it was paid to, how it was paid. So the court came in and said, they looked at the intent of the statute, not the language of the statute, but the intent of the statute, which states detailed records of receipts and expenditures, which bank records are, that you can't deny that. And I add, and the court held, the Court of Appeals determined that dismissal was not appropriate because the lower court had just dismissed it, and that bank statements may be records required to be produced. Analyzing the plain meaning of the words for the statute, the court determined that a bank statement is a record, that it is detailed, and that it is therefore is a detailed record of receipt and expenditures to the extent it reflects deposits and withdrawals. The court declined to adopt the association's argument that the records created by third parties are not records of the association, noting that other records specified in the statute, such as reserve studies, are typically created by third parties. So essentially, the association came forward and said, look, we gave them our records. We gave them the records we created. And the court, looking at the statute, said, no, the bank records are detailed. They are records. They are association records, and therefore required they be provided. And I go with the moral of the story as to records. This is one where the records satisfy the requester really in the eyes of the requester. They're not in the eyes of the association. And it's yeah, you have this list of records, but it's, if the record is even close, give it. Courts have bent over backwards to get information to the individual owners. The courts are going to continue to find that. One is a friend attorney of mine that I practice with in this wonderful area of law, is you have the intent of, what are you hiding? Why are you trying to hide something? If it's a record, if it's even close, give it. It's because, again, this is coming to the concept of, if it's even close, give it. Don't hide behind the technicality of the statute, because the courts are not going to do it. The courts are not going to buy it. And let me see, it says, Nicole's comment of finding the court did something correctly, I can't argue, but it comes back to, yeah, your records are more, like I said, in the eyes of the beholder. They're not in your eyes, and they're going to require you give the records. So that being said, what's going on outside of the state of Colorado? And this will, again, kind of give you a hint of where other associations or other courts are leaning. And where other courts are leaning, it's, again, not necessarily binding, but it is probative, and it can be brought into it. And this one regards neighbor-to-neighbor disputes. And I just had a conversation or an email conversation with a manager today concerning how far should the association go to get involved in a dispute. And my response, as always, was don't. It's Donna, I was going to mention that at the end. The attorney's fees case, it's coming. Let me get through this, and I will definitely get back to that. So in this case, Mr. Woodland hated his neighbor, and his neighbor hated him. And it's the facts of the matter were these two neighbors, they hate each other. They were doing everything they could over the course of years to piss each other off. And it came down to a covenant enforcement matter led to an unfortunate dispute between neighbors that got physical. Essentially, it got into a fight. And the basis of the claim was a long-standing dispute between an alleged harassment that never was addressed by the association. And the two owners, they were just pissing each other off intentionally. So it broke out into a fight. And as a result of the fight, one guy got beat up. And he sued the manager, saying, "Manager, you never enforced the covenants. And I know we were pissing each other off, and I know it was occurring over a couple of years, but you didn't get involved, and you should have gotten involved." So here, this is an appeal following a summary judgment in favor of cross-defendants and respondents, the real estate company, the management company, and the homeowner association. They were, as the court put it, Regent and Greenhouse were unfortunately dragged into litigation that shouldn't have remained between two sets of homeowners, Woodland and Hall. The defendants and cross plaintiffs on the one hand, the plaintiffs and cross defendants Eric Smith and Stacy Thorne on the other. As irrelevant to this appeal, the trial court properly granted summary judgment to Regent and Greenhouse on the Woodland and Hall cross complaint. On appeal, Woodland and Hall only raised the negligent cause of action. Woodland and Hall have failed to establish or even articulate a duty of care that was breached by Regent or Greenhouse. These were just bad neighbors intent on pissing each other off. They absolutely did everything possible, and it went too far. And the court said, essentially, you brought this on yourself, and you should not have dragged the association into this. And since you did drag the association into this, we're going to dismiss them because the association had no duty to intervene in this dispute. They weren't really covenants being violated, and even if they were covenants that being violated, we didn't have to enforce it because you were doing it deliberately just to piss each other off. All right. So before I get too far, what about the record? Okay, Jack, more on the records produced. What about records produced as a result of an executive session, say record of attorney turnover for collection? No, you do not have to produce those. Those are specifically executive session records, which the statute states the board may determine to release those or not. But since the legislature specifically stated you must consider turning matters over in an executive session, you should not turn those records over. They're not records made. Plus, on the flip side of that, please remember there is a provision that says in the Colorado Communist Ownership Act that says records involving a unit other than the requesting owner are not records to be made available for inspection and copying, and they can be absolutely withheld from inspection and copying. So going on, we'll come back to some of the others. Actually, let's finish up on these two. Maury, the Heather Gardens case, does the term records include copies of the contracts that the HOA has entered to with third-party providers? It absolutely does, because Colorado law specifically states you must make available for inspection current contracts and contracts completed within the last 2 years. Those must be made available for inspection and copying. So quite frankly, that's not even the Heather Gardens case. That's a different section of the Colorado Common Ownership Act. But yes, those are specifically required to be addressed. How would Colorado handle neighbor-to-neighbor disputes? I think in the exact same way. You, the association, are not compelled to get involved. Specifically, remember, you've got unless it's a life, health, safety violation, you've got 30 days. The owners have 30 days to cure anyway. So if it's blasting radios, can you send a notice out? Yeah, you sure can send a notice out, but they have 30 days to cure that. If it is, kind of doing things in a community, if it's really harassment between two owners, tell them to call the police. This is not, you, the association, are not a police force. You, the association, are not required to get involved with, again, physical violence. A neighbor, flashing a light in the neighbor's community or home. These are just not things the association is required to get involved in. Have them call the police. And I think Colorado would handle it the exact same way. This is not an association obligation. Okay. I love chickens. Y'all know I love chickens. I think they're wonderful. And this case involves the Schroeders and Oak Grove Farm. This is out of North Carolina. And essentially, what happened is in 2017, the Schroeders acquired a 17-acre lot. Now remember, this is a 17-acre lot in the homeowner association. The Schroeders and Oak Farm, over the course of that time, built a chicken coop. Other owners had pet chickens, and so they built up their flock. The other owners didn't quite have as many as the Schroeders. So the association ordered them removed. They fined the owners, and there's to put a little more flavor on this. In March of 2020, the association's property manager sent a letter to the owner demanding the removal of the chickens. Owner then relocated some of the chickens, but still visited those chickens that were relocated. After a hearing, the association board found the owner in violation of the restrictive covenants, prohibited poultry of any kind from being kept on a lot. The board levied fines for the violations, which amounted to $31,500. The appellate court conducted extensive examination of the trial testimony of how the owners interacted with the chickens. The testimony included that the chickens liked to be held and carried, that the owner spent up to 2 hours with her chickens each day, bathed and blow-dried them in the house, took care of their medical needs. The owner indicated that every chicken knew its name and would come when called. The chickens were not bred for meat, and none of the eggs were ever sold. After having some of the chickens removed, the owner drove over an hour each way, once or twice a week, to visit the chickens. Neighbors also testified that they saw owner holding the chickens and spending a lot of time with them. By contrast, the association presented no evidence on how the chickens were kept and did not dispute the owner treated or cared for the chickens. Instead, the association presented 2 board members who testified the chickens were not pets. And the court found this incredulous, and it said, look, the chickens are pets, and I don't care how many chickens you had, they were allowed to stay. And it gets to that kind of disparate treatment and absurdity of certain things, that if you're on 17 acres, you should be allowed to have chickens. And they were, for lack of a better term, an emotional support flock, seeing how she cared for them, blew-dried their hair, made sure they were all comfortable, and tucked them in at night, went to see them, knew their names, they came running. And I will tell you, having had chickens, I can absolutely agree. These chickens know their names. These chickens each have their own personality. And if I cared enough, and it's not that I cared enough, but it's more of along the lines of, I have pictures of me with my chickens sitting on my shoulders and loving them up. So the chickens are wonderful. And I think that a lot of the complaints are not necessarily around the chickens, but it's around the, the noise they may or may not create. So So you've got, is a homeowner walking around the courtyard intoxicated and their guests considered enforceable nuisance? Michelle, it's a good question. If they are causing problems in the community, you know, they're walking around, if they're just walking around drunk and kind of falling and passing out, no, that they're not. It's not an enforceable nuisance. But if they're going and banging on everybody's door and yelling and screaming and coming in and peeing all over the place and throwing bottles all over, yes, that's enforceable. But it comes down to, how do you enforce? You send a 30-day cure period. Then you send another 30-day letter and fine them up to $500 for the infraction that they can keep doing. I think it's while it may be enforceable, legally, practically, it's not as enforceable as we would want it to be. And then, Lon, in the dispute between the two neighbors, what is the obligation, if any, for CCR violations for the alleged covenant enforcement? Again, it's as we kind of discussed on the enforcement piece. It depends on the violation, and if it's really just a nuisance between two homeowners, I know that, you know, kind of as a general statement, we won't touch a nuisance case unless it impacts 2 or more or 3 or more owners, because it's really just a private nuisance between owners, and you can't really get at the targeted harassment of 2 owners. And so I get it that, Michelle, the police are called frequently. I understand that's the best you got. That's the best you can do. Maybe do a wellness check, but you can't necessarily, you don't have effective tools through the state of Colorado to address that type of behavior, is really where I'm going with this. All right, so the next one, waiver of covenants, and this came out of South Dakota. And here, the facts are, Clyde and Nancy Stratmore bought a lot within a subdivision and started to build a home with a 3-car detached garage for an RV. Yes, RVs are still 4-letter words. I understand that. The neighbor sued. And the holding, in this case, is the circuit court did not abuse its discretion when it declared the restricted covenant void because, oh, everybody else had detached garages. Oh, everybody else had RVs stored in the community. It's the truly selective enforcement of these, the assessments that, or the covenants that the courts are really starting to hammer down on. And here, the trial court found so many violations of the covenants that it fashioned a remedy would be to make everybody take all their stuff down and start over. Essentially, wipe the community out and start from scratch. If we're gonna have strict adherence to these covenants, the court went scorched earth. In doing so, it noted that the violations were widespread, unchallenged, and the restrictive covenant throughout this restriction, some of which were perpetrated by the plaintiffs. So they had the exact same violation on their lot that they were trying to enforce. So the circuit court determined that it would be impractical and harmful to require all the properties to be brought into compliance. And guided by these considerations, the circuit court determined that requiring the Stratmores to conform their property to the restrictive covenant while allowing plaintiffs and other property owners to violate it is inequitable. Essentially, the court came out and said, you violated your covenants. Everybody did, and therefore they're waived, and those covenants are deemed worthless. Colorado's a little bit more stringent on how to determine a waiver of covenant, but would probably come up with the exact same conclusion given the violations in that community. It just wasn't. You can't sit there and it's the days, even in South Dakota, the days of the Wild West are gone. You have covenants, you have to enforce them as written, and if you don't like them, change them. So, all right. Here's a reasonableness standard. And this comes down to, quite frankly, wanting to do something versus not wanting to do something versus whether it's what's been in place. The Wongs wanted to enclose the hallway between their 2 apartments. Okay, so they bought two condominium units, hallway in between it. They wanted to enclose it to make it theirs. This was apparently common in the community as long as you paid a hallway takeover fee. Everybody else paid it. I didn't want to. And the holding of the court was the board had the authority to adopt the fee. Colorado law allows for the adoption of this type of fee as well. And the fee was reasonable because it addressed what was involved in taking over the hallway. And essentially, the bottom line was, instead of buying the common element hallway like everybody else, Ms. Wong decided to sue. The moral of the story is that if your fees are reasonable, you have leeway to adopt the fee and insure it, but to have it paid. But again, you've got to make sure the fee you are trying to charge is based on reality. It can't just be this swag coming out of midair or because you want it. It has to be based on some semblance of reality of what it costs or what the square footage is or what the, how you are assessing it. Okay, Donna, what is your question? What if their lots are 6,000 square feet in close proximity to the other homeowners? I would assume the covenants can be enforced. Yeah, they can be, but again, it's got to be reasonable. And I've seen more and more courts going with chickens or pets. They're not necessarily poultry, because I know most associations out there, most covenants out there say no poultry of any kind be kept in the community. And yet now, again, through changing of time, through the concept of backyard chickens and people getting exposed to them, I think if it's just a chicken, that is just a backyard chicken, I think you probably have to look on the reasonableness of what you're trying to accomplish. But if you do have a no poultry, you can try and enforce it. But I think that is starting to become a losing ballot or losing argument, because you're starting to see, one, chickens have to be in a flock, and two, you're starting to see a lot of homeowners claim, oh, these are my emotional support chickens, and the courts are buying those arguments. They are soothing, and they're not just out there mindless little beings. They do come when called, and they do come running up, and they do provide comfort. And so I think that's going to be a very factually specific statement, and I understand the problem you're also going to have. And again, I had this when I had my chickens, and I think anybody that keeps chickens is, as my exterminator once put it, a chicken coop is Club Med for rats, because in the winter you've got heating lamps, so you're providing heat, and you've got hay that is good for a burrowing rat for shelter, and you've got food, and the rats get it's a smorgasbord of food. So I think generally speaking, you can go at the nuisance clause, but you can go at the vermin and nobody should keep something on a lot that causes an infestation of rats and mice. And then doesn't this change the plat map? It's no longer common element. Yes, it does. And according to Kiowa, you would have to go out for a vote. This was a very specific case outside, but I'm using it more for the reasonableness of the fees. But if you are selling common elements, yes, it changes absolutely the condominium map. It changes the map, and it requires certain things. Let me get to my very favorite case before we run out of time. And this is Al Hamini versus Star Hearthstone. And this has absolutely nothing to do with association law, except for the fact that you are starting to see more and more owners come up with AI constructed briefs or AI constructed arguments. And the facts here, Al Hammin entered into a lease which he promptly alleges that he could not use due to strong cat urine smells, sued for violations of the lease. No, wait, time out. In this violation of the lease, his lawsuit was prepared using AI. And in his lawsuit, it alleged certain things that nobody checked, except for the court checked, and opposing counsel checked it. And as a matter of law, the court found that an LLM-based AI learns what words are most likely to appear, where and which ones are most likely to proceed or follow others. And by doing so, it can make probabilistic, predictive judgments about ordinary meaning and usage, and that because of this, the LLM hallucinates and are not consistently reliable legal research tools. They do not always provide the correct answers to legal inquiries and even make shit up. And I use the wonderful colorful language. They make stuff up, including case names and citations, when they do not know the answer to the question. So they, by definition, in the state of Colorado, AI lies. It hallucinates. And when it hallucinates, it produces documents to fulfill its argument. And my comment in the moral of the story is, have we not seen the Terminator? Oh my God, it's coming. AI is already taking over the world and lying to you and telling you things that don't exist. And with that, I would like to thank everybody. We're out of time. Oh, real quick, before you go, there's an attorney fee provision case, Far Horizons v. Flying Dutchman. Essentially, it states that the proportionate, you can't proportionately assign attorney's fees. It's an all or nothing proposition. So when you go out on a covenant enforcement matter, you have to win on 50.01% of the case, or the attorney fees may go the other way. Thank you so very much. Email me or call me about that for our Horizons case if you have any questions. And I'm sorry I went long. And Nicole, we love you too. Thanks, everybody. You're the best. I love you all. Have a good night.